Hello and welcome to Ukrainian Flames, a special project by Ukraine Crisis Media Center, NGO Euroatlantic Course, and Analytical Center of Ukrainian Catholic University. My name is Victoria Zabian, I'm head of the UCMC Press Center. Please like, share this video, and subscribe our channel to stay tuned. It is extremely important for Ukraine to bring to justice all those behind all crimes of Ukrainian land. How it is process of bringing Russia to justice for war crimes going on, practices of international and Ukrainian courts, what punishment is possible, and other issues to explain what is happening in this area. These questions will be covered in today's speakers. And we start with expert Kateryna Rashevska, who explains the key definitions of mechanisms. First, let's take a look.
Ensuring that the perpetrators and Russia in general will held accountable for international crimes is one of the guarantees that the horrors of war will not be repeated in the future. In this video, we will look at the mechanism for bringing individuals to justice for international crimes and the challenges that will arise in their application. But first of all, let's define the key terms. The state's international responsibility is the responsibility for an international wrongful act, which takes the form of restitution, confiscation, and satisfaction. Regarding Russia, we will first talk about the payment of reparations to victims of international crimes and Ukraine as a whole. We can already see the first of such responsibility, namely the freezing and confiscation of Russian assets abroad. International individual responsibility is a traditional regime of criminal liability providing for the punishment of individuals who have perpetrated international crimes. International crimes cover four categories of the gravest offenses of concern to the entire world community, namely genocide, crimes against humanity, war crimes, and aggression, crime against peace. As several different levels of justice have already started their activity, it is clear that in the post-conflict reconstruction period, we will witness simultaneous trials in both national and foreign, as well as international courts. It is important to emphasize that a person cannot be prosecuted for the same crimes twice, non bis in idem principle. Therefore, a kind of gradation of evil will inevitably become, according to which national courts will take care of perpetrators of international crimes, while the ICC and alternative instances of perpetrators and those who gave criminal orders and were involved in decision-making processes at the highest level. This division is quite conditional and doesn't deprive the opportunity to sit on the dock of the Ukrainian or foreign court, for example, Sergei Narishkin or Valentina Matvienko. Among the challenges facing the Ukrainian authorities, firstly, inconsistency of criminal legislation with international standards and gaps in it. For instance, lack of criminalization of crimes against humanity, blanket rule on war crimes which worked only 4 times, the vague wording of aggression which has already led to the confusion in the case of Alexandrov and Yerofeyev, and so on. Secondly, the difficulty of obtaining evidence and ensuring the participation of defendants. And thirdly, lack of legitimacy, the so-called defect of the court of winners or revenge of the victim. Foreign courts may also administer justice for international crimes following the principle of universal jurisdiction. Today, it is known that about 10 European countries have launched investigation into war crimes committed on the territory of Ukraine under this principle. These are Sweden, Germany, Poland, Estonia, Lithuania, Slovakia. In total, there are 17 countries in the world whose criminal legislation contains provision on universal jurisdiction, and Ukraine doesn't belong to them. The challenges in foreign courts are similar to those already described for competent national authorities. In addition, it should be borne in mind that perpetrators of both parties to the conflict may be on trial. The next instance with jurisdiction to administer justice for international crimes committed during the Russian aggression is the International Criminal Court. Ukraine has not yet ratified the Rome Statute of the ICC, but has twice recognized the court's jurisdiction under Article 12. On March 2, 39 states, later joined by Japan and Northern Macedonia, appealed to the ICC Prosecutor's Office to conduct an effective investigation into international crimes committed during the Russian invasion of Ukraine. In the ICC context, it should be noted that the prosecution process will cover international crimes committed by both parties to the conflict. Concerns about this are still one of the most frequently cited arguments of opponents of the ratification of the Rome Statute. Moreover, patience is also needed. The ICC process can take decades because, unlike the National Court of Criminal Procedure, the Rome Statute doesn't provide for any time limits. For instance, the situation in Colombia has been under preliminary examination for 18 years. There will also be barriers for the ICC in accessing the evidence base and extraditing suspects. In this context, reference should also be made to the case of the Ahmad al-Bashir. 10 years ago, 2 arrest warrants were issued against the former president of Sudan, but he continues to hide in states that refuse to cooperate with the ICC. After all, the court has no jurisdiction in the case of Ukraine to prosecute the crime of aggression. Firstly, because neither Ukraine nor Russia is a party to the Rome Statute and has not adopted the Kampala Amendments, which launch the jurisdiction of crimes against peace. Secondly, because Russia has a veto in the United Nations Security Council, as a result of which this body cannot endow the ICC with the necessary competence in accordance with Article 13 of the Rome Statute. Thirdly, even if both states ratify the Rome Statute and the Kampala Amendments, such an act will not have a retroactive effect. Thus, other mechanisms should be sought to prosecute aggression, as national and foreign courts have another major drawback. They do not address the jurisdictional immunity of heads of states when aggression is a leadership crime. Therefore, if the ICC has no jurisdiction and the legal status of high-ranking officials paralyzes national courts, the only option is to set up a special tribunal to prosecute aggression. A special tribunal on the crime of Russian aggression could potentially take 2 forms, an international or a hybrid court. In the first case, which now seems to be favored by the professional community, an international treaty modeled on the London Declaration and the Nuremberg trial will be concluded, giving the special tribunals the power to take binding decisions, probably in absentia. In the second case, Ukraine must apply to an international organization and, based on an agreement with it, create a court that will be a part of a judicial system of our country, but will be mixed in the exercise of jurisdiction ratione materia and ratione personae. Therefore, the future system of the post-conflict justice will be at least 3-tiered: national, foreign, and international courts. It will be based on the determination of the international community to protect the common values: peace, security, and the rule of law. The importance of such a structure is difficult to overestimate. Its effective functioning will restore the faith in international law and ensure the inevitability of international responsibility for those who committed the gravest international crimes.
Mykola Khavroniuk, member of the board of the Center for Policy of Legal Reforms, especially for our project, commented the real ways how to prosecute those who are guilty.
Існує 3 можливості притягнути винних осіб до кримінальної відповідальності. Перша можливість – це створення спеціального трибуналу щодо злочину агресії І він потрібен з огляду на необхідність подолання дипломатичного імунітету вищого політичного керівництва Російської Федерації. Через національні механізми це неможливо зробити. І нібито робота щодо створення такого спеціального трибуналу почалась, але поки що це на рівні декларації і підготовчої роботи. Українські юристи підготували проекти для обговорення з міжнародними партнерами. Є підтримка Ради Європи, Європейського Союзу, 42 країни проголосували за створення такого трибуналу. Але коли він буде створений, скільки він буде часу займатися розслідуванням і судовим розглядом цього одного злочину агресії, це нікому не відомо. Але це тільки про злочин агресії, тільки стосовно вищого політичного керівництва Російської Федерації. Друга можливість для того, щоб притягнути до кримінальної відповідальності, це політичне керівництво, діяльність Міжнародного кримінального суду відповідно до того Римського статуту, який ми не ратифікували, але разом з тим це не заважає відповідному розслідуванню. Як відомо з повідомлень засобів масової інформації, ще 3 березня прокурор МКС пан Карім Хан повідомив, що почав розслідування воєнних злочинів і злочинів проти людяності. І нещодавно, в травні, в Україну прибули близько 40 слідчих, які будуть займатися такими розслідуваннями. Але тут проблема в тому, що не визначено чітко межі, де розслідує Міжнародний кримінальний суд, або стосовно яких суб'єктів, або за яким саме предметом, і щодо яких суб'єктів, за яким предметом проводять розслідування українські прокурори. Станом на сьогодні це третій елемент, який є можливим. Національна українська прокуратура проводить свої розслідування. І з цією метою зареєстровано по порушеннях законів та звичаїв війни близько 10 тисяч, вже, напевно, понад 10 тисяч кримінальних проваджень. Але тут існують проблеми в тому, що не існує спеціалізації слідчих, ні слідчих СБУ, ні слідчих інших відповідних органів, не існує спеціалізації прокурорів для розслідування всіх цих 10 тисяч злочинів. І головне, що не створено спеціалізованого суду для їх розслідування. І навіть не запроваджена спеціалізація суддів, а розслідування надзвичайно специфічні. І тому от станом на сьогодні, попри те, що вже кілька місяців триває війна, і ті розслідування, які давно розпочались, лише одного військовослужбовця Росії вдалося засудити, і це рядовий.
We also have managed to get the comment from Oleksii Plotnikov, PhD, international legal expert and officer of the Territorial Defence Forces. Let's listen to his points.
Hello, we're from Ukraine. My name is Oleksii Plotnikov, and most of my time I'm an expert in the field of international law and a practitioner. But now I'm an officer of the Territorial Defence Force of Ukraine. And I was asked to elaborate on the modes of responsibility of the Russian Federation and individual perpetrators for war crimes being committed in the present conflict. This conflict is multi-layered, just as responsibility is going to be multi-layered. And we must distinguish between two types of responsibility. International responsibility of the state for a violation of its international obligations, and individual criminal responsibility of people. Speaking of the responsibility of the Russian Federation as a state, it consists of the responsibility for the violations of certain international norms that is going to be declared, well, most possibly by the International Court of Justice, as in the case of the Anti-Genocide Convention and possibly some other international courts or international arbitrations. Secondly, we're speaking about material responsibility for the property destroyed in Ukraine and for material damage done to Ukraine that is going to take place in the form of possibly enforcement of domestic or international judicial awards or some other mechanisms created as part of the sanctions against the Russian Federation. However, what is most important and what creates more questions is the individual criminal responsibility. And here we're not speaking about the responsibility of the Russian Federation as the state. We're talking about the responsibility of people inside the Russian Federation. And on the one hand, it is of paramount importance to achieve this responsibility because the absence of such a responsibility would create something called impunity, which means that the perpetrators are not going to be brought to justice, which means that the victims are not going to receive justice in their grievances. And this is likely to create a circle of violence that can repeat itself during the lifetime of the next generations. In order to achieve the responsibility, the individual criminal responsibility of each and every person responsible for those crimes committed in Ukraine, including both people on the Russian side and on the Ukrainian side. We're not talking about exclusively about the responsibility of the Russian perpetrators, because there can be war crimes being committed on the part of Ukraine. In order to achieve this responsibility, we have several mechanisms. There is a lot of discussion about a possible international tribunal for the conflict in Ukraine, but we must understand that it is Ukraine that is going to be at the lion's share of the work aimed at achievement of responsibility and avoidance of impunity. And an international tribunal is being actively discussed now. And we have basically two options. Option number one is the International Criminal Court that has jurisdiction over war crimes and crimes against humanity committed in Ukraine. And Ukraine did recognize this jurisdiction, although it never became a party to the Rome Statute. The second option is a special tribunal that is going to be used for those crimes that are that don't fall under the jurisdiction of the International Criminal Court. And those crimes that fall within its jurisdiction are mostly those crimes committed by mid and low-level perpetrators, like the generals and the soldiers, and there's the war crimes and crimes against humanity. But the crime of aggression falls outside of the jurisdiction of the ICC, and that's why an opportunity to create a special tribunal for the act of aggression against Ukraine is being discussed right now. And this is pretty complex from the legal point of view, however, not impossible. Another thing is individual criminal responsibility for genocide that is on the table in the International Criminal Court, and this possibility is also being discussed. And it is possible that certain high and mid-level officials are going to be brought to justice via those international mechanisms. However, I would like to underline once again that it is Ukraine that must prosecute those responsible. And, most of those responsible, like 99%. And what we can see now is the first attempt to achieve responsibility of an individual perpetrator, a Russian soldier who murdered a civilian. And this process is important, however, not flawless. And I can see a huge number of risks connected to this process, mostly because it was this process was run in haste, and there are serious and reasonable doubts about certain procedural aspects of this process, And I can see very high risks that this sentence can be challenged before the courts of appeal and possibly even before the European Court of Human Rights. And for this reason, Ukraine must not haste with the prosecution. Those processes against the perpetrators must take place at the highest possible standard of impartiality and due process. And this is a bunch of hard and long work, but this is work for the future, and that's why this work is important. Because thanks to this work, we will be able to achieve justice, to avoid impunity, and to destroy that circle of violence. Thank you.
Masha Stolbova, international lawyer, explained the difference between state responsibility and individual criminal responsibility in conditions of war. Details you can watch in the following video.
When we answer the question how Russia will be held responsible for the war crimes in Ukraine, we first should define the scope of the mentioned terms. In international law, war crimes generally refer to a wide range of gross violations that happen during the armed conflict. There are several documents guiding the behavior of combatants during the armed conflict. In wide terms, they are known as the Law of the Hague and the Law of Geneva. Our core interest within the scope of the war crimes question is the Law of Geneva, and namely 4 Geneva Conventions and Additional Protocol Number 1. These conventions codify customary norms of international law. This means that all the states are bound by them, even if they are not state parties to the convention. At the same time, the widely used in media phrase war crimes often refers not only to the violations of the Geneva Convention, but also to the wrongdoings committed during the war. Therefore, I will briefly describe the general question of Russia's responsibility and pay special attention to responsibility for the war crimes in the meaning described above. The first thing we should do today is to understand which unlawful actions are in question. First, we face violation of the international treaties, UN Charter, Geneva Convention, that take the form of armed aggression, destruction of civilian objects, environment, cultural and natural heritage, mass killings of civilians, tortures, rapes, and other acts of unspeakable cruelty, destruction of private property, loss of investments, and others. Further, we face violations of the customary norms of international law and the general principles of law, violation of territorial integrity, sovereignty, prohibition of the threat of use of force, or prohibition of use of force. The same violations simultaneously trigger several regimes of responsibility at the level of state and at the level of individuals. Starting from the state responsibility, here we talk about the wrongful action attributable to the state as the subject of international law. All actions of state officials performed in their official capacity automatically constitute actions of the state. What are the judiciary bodies to address this issue? The primary, however not the most effective one in this case, is the International Court of Justice. It already considers 2 ongoing disputes between Ukraine and Russia. The first was launched back in 2017, based on the Convention on the Suspension of the Financing of Terrorism and on the International Convention on Elimination of all forms of the racial discrimination. This dispute has successfully passed the jurisdictional stage and now is on the merit stage. The other case was launched by Ukraine on the beginning of the full-scale Russian invasion on the basis of the 1949 Convention on the Prevention and Punishment of the Crime of Genocide. The idea of such reverse claim is to prove that Russian allegation of genocide used as a basis for the armed aggression is false and respectively Russian armed aggression is unlawful and unjustified. The core challenge faced within this court is the limited jurisdiction. The whole system of international law is based on the equality of states and therefore on the utmost value of their consent. This can be seen also in the acceptance of the ICJ jurisdiction. Most treaties exclude automatic ICJ jurisdiction in disputes, while Russia obviously doesn't want to provide consent for the jurisdiction in other cases. Russia can be brought to responsibility as a state also in arbitral tribunals. This is one of the most flexible forms of the justice in international law. These tribunals deal majorly with commercial and investment issues, finding the jurisdiction in commercial agreements or bilateral investment treaties. This means that the core scope of these claims will be the private property and the investment. Finally, Ukraine may resort to the UN Human Rights Council and the European Court of Human Rights to address Russia's complete disregard for human rights. The proceedings against Russia as a state are important as they allow obtaining their operations, and of course the compensation will be the core here. But the real achievement of international law is a system of individual criminal responsibility that was actively developing after the Nuremberg trials. Individual responsibility is the most effective tool to bring criminals to justice, as well as it is an absolute importance for the victims of the crimes. Due to almost 70-year evolution, today we talk about the International Criminal Court as a central body to bring the top-ranking perpetrators to the responsibility. The ICC has opened the investigation in the beginning of the full-scale aggression, and this investigation is supported by 42 countries. The Joint Investigative Task Force has already come to Ukraine to collect evidence. Under the ICC founding document, Rome Statute, the court has jurisdiction over crimes against humanity, war crimes, and genocide. I specifically do not mention the crime of aggression, as the ICC will not have jurisdiction for it in case of Ukraine. ICC is limited in its resources and will consider the cases of up to 20-30 top perpetrators. So the main duty will be on the Ukrainian prosecution bodies and the courts to bring every perpetrator to justice. We have already witnessed the first verdict for the Russian criminal, and 40+ cases are already prepared for the court hearing. A separate attention should be paid to the crime of aggression. It was introduced in the Rome Statute in 2010, while the jurisdiction emerged in 2018. Due to the absence of the ICC jurisdiction in the Ukrainian case, there is a reasonable need to institute a separate tribunal to address this cause. It can be done by analogy with the ICTY, International Criminal Tribunal for former Yugoslavia, or ICTR, Tribunal for Rwanda, initiated by the United Nations. Our authorities and scholars already work on it. To summarize, there is a need for a united action against Russia and its officials to bring the justice and to stop any dictator from committing the same crimes in future. The existing efforts are strongly supported on the political level in numerous countries. Therefore, we are likely to witness the global justice for the Russian criminals.
You've been watching Ukrainian Flames, a special project by Ukraine Crisis Media Center, NGO Euroatlantic Course, and Analytical Center of Ukrainian Catholic University. In description to this video, you can find the information about how personally you can help Ukraine against Russian aggression. Everything is gonna be Ukraine.